Welcome to the Dorée Holdings Limited.
Morning, Mr. Governor.
My Lords, I appear in this appeal for the appellant. Learned friends, Mr. Nicholas Dowding and Mr. Stanley Marcus, appear for the respondent. My Lords, I make the usual assumption that your Lordships have been able to read the statement of facts and issues and the parties' written cases.
We put a lot of yellow stickers on the papers to show something, Mr. Governor.
Yes, well, Lord, I know that's not just a ruse. And obviously probably a good deal more than the documents I've mentioned, so that you'll appreciate that the principal, if not the only matter before your Lordships, is the meaning and effect of provisions contained in the lease,
yes,
which we have attached to the appellant's written case. And in particular, as a result of correspondence, you are not going to be asked to consider investigate the factual issues about agricultural development at the River Dorée farm.
Right.
That, of course, occupied a great deal of time at first instance, but the Court of Appeal decided that they didn't need to consider it on the basis of their interpretation of the provisions in the lease.
Now, just to put the whole case in perspective, if you're right, of course, then you can reject the notice to purchase, and what is the position? The lease will simply continue at the moment, subject to any steps you may propose to take under the Land Acquisition Act.
Now, I think the Land Acquisition Act has already been activated. So
when you say it's been activated, a letter was written.
I think that the land has been compulsorily acquired. That's what I understand of the position. So that what
I see. So that postulates that the lease was never determined.
Well,
it postulates that what happened was that it was confiscated.
The result of the appeal, for practical purposes, would have an impact on the amount of compensation which the government would be obliged to pay in respect of the compulsory acquisition of the land.
I see. Because
in other words, they would have either compulsory acquired something which was effectively theirs in the first place, or they would have compulsory acquired something which the respondent had a substantial interest in.
well, you say something that was effectively theirs anyway. How was it
theirs?
theirs?
They were entitled to reject the
I see. So,
new lease.
but the mere
Can I just hear you?
yeah, rejecting.
Please explain. I'm trying to understand what you've just been telling us.
Well, my understanding of the practical effect of it is that if we're right, we were entitled to reject the
purchase notice.
yes, that the
But that doesn't mean to say there isn't a lease. And you, at one point, gave notice of intention to determine the lease, but your pleading says that that was overridden by the Land Acquisition Act notice. So the Land Acquisition Act notice only makes sense on the basis that the lease remained in force. So you would still have to pay some compensation, presumably, although unless you're saying that you had some sort of residual right to determine which you could still have exercised, but it'd be rather late to do so without giving notice.
Well, that's why I
reasonable
think
time.
the practical consequences go to the amount of compensation, which would obviously be considerably greater if they were entitled
To purchase.
All
right. So that we've got the basis of the basic position clear.
Yes. Well, the issue in the appeal being what it is, I would go straight to the lease and begin, if I may, with what I take to be two entirely uncontroversial matters. First, that the lease must be considered as a whole document. And secondly, that the object is to ascertain the meaning of the provisions and so the intention of the parties. I would ask you first to look at recital E. It's perhaps most convenient to look at that attached to the written case, but if your lordships are in the electronic bundle, it is at E2334, and you will see the wording of it. Let's see at the end of the first 10-year period of this lease, will be permitted by the government to purchase the then remainder of the land and buildings in Schedule 5, provided the lessee has satisfactorily carried out the terms and conditions of this lease, including the development program for the site Eastern Caribbean currency $10. And the government will grant to the lessee, under the Aliens Landholding Regulation laws of St. Lucia, to hold as owner such land and buildings. And I was like to ask you, before considering anything further, to notice how and why the recital came into being. In particular, there are 3 documents which I would want to take you to. We would say that they don't have anything to do with the negotiation of the terms of the lease. They were all introduced into evidence by the claimant, River Dorée, through its witness, Søren Hofdahl. And Mr. Hofdahl was in fact the only witness who gave live evidence, who was directly concerned with the events surrounding the creation of the lease in the first place. His witness statement, my lords, is at page 1198. If you're using paper bundles, it's volume 3 towards the end volume.
Yes, volume 3, 1198, right?
Yes. And the passage in his witness statement I wanted to go to first is paragraph 3.1, which is on page 1200, where he says, on 20th June 1986, we got permission to lease the lands by letter of even date to our solicitors McNamara and Company. I signed the lease document on the 20th of February 1987, and the license having been issued on the 12th of January 1987.
We got permission, we being the...
We
the
at that
Danish
stage...
Foundation?
I'm sorry. Yeah. Yes, the River Dorée was in fact incorporated for the purposes of the lease. Negotiations had originally been undertaken by, I'm not going to pretend I get the pronunciation right, but I think it's Félicégé or something like that. Félicégé, in fact, has interests not only in St. Lucia but elsewhere in the Caribbean and in Central America. But if I can take you to those documents, but before doing so, perhaps remind your lordships, I'm sure this is something that you have appreciated, that for a company with alien ownership, it is necessary in St. Lucia, as in many other of the islands of the Caribbean, to have an alien landholding license. That has been considered in a number of decisions, but it's a part of the local law, and it applies in St. Lucia. The first of the documents is at page 1245. That's the letter dated the 20th of June 1986, and it's addressed to Mr. McNamara from the Permanent Secretary of the Minister of Agriculture. He says he's pleased to inform you that Cabinet agreed to the acquisition of a property.
Well, I think we've
Yes.
read the letter, and
Well, the important,
we can read it again.
Yes, the important part of it, my lords, is the last main paragraph on page 1245. If after 10 years of the lease Felicege brackets the Danes have developed the property in accordance with the terms of the lease, government will sell the property to them for the sum of $10.
Well, this is an agreement to agree. You don't suggest this gives rise to legal rights.
The letter doesn't, no.
No. Well, it's simply part of the negotiations, isn't it?
Well, Lord, it is recognising.
If I say months in advance, this is the sort of deal we're aiming at, it turns out a bit different.
Well, except that it didn't turn out a bit different.
Well, that's the question.
Because, and that's the next document I'm going to take you to, because my learned friend says, well, this shouldn't be, I'm going ahead of myself a little bit, but in his case he says, well, this is all a long time before the lease was actually granted. But the answer to that with respect is that it's not a long time before the lease was granted, that the license was granted. And that is the next document I was going to take you to, at page 1247, which is the landholding license. And it contains, first of all, the date is important, 12th of January 1987, which is a very short time before the lease is signed. And the second schedule contains conditions upon which the license is granted. And condition A, the lessee shall develop the property in the first schedule in accordance with the lease made between Her Majesty Queen Elizabeth II and River Dorée, dated 20th of February 1987, and B, if after 10 years of the lease the lessee has complied with A, the government of St. Lucia will sell to the lessee such of the property in the first schedule has not been disposed of in accordance with the terms of the lease for the sum of $10. So this is the position in January 1987, immediately before the lease is signed. Well, for completeness' sake, there is also the letter which is referred to by Mr. Hofdahl.
Can I just ask, how come that this document, dated the 12th of January, has a reference in it to a lease dated the 20th of February?
Well, I'm afraid the dates are not explained in the documents. We only have what Mr. Hofdahl said about it, which is, I've already shown you the passage in his witness statement on page...
They've got stamps of the 30th, 10th and 30th?
10th of December 1986.
Yes.
Yeah. Well, the point I make is that it is it does have legal consequences. It's the landholding license which is subject to the conditions which are set out, and those correspond with the recital which is contained in the lease. They also, for sake of completeness' sake, correspond with the other letter which Mr. Hofdahl produced in as one of his exhibits, which is SH2 at page 1228. That's the letter of June the 24th, 1986. And that's the letter which is from the Prime Minister himself.
What page again was that?
That's 1228.
Yes, thank you.
The second to last paragraph. If, however, your clients carry out an agreed development program, your clients will, after a period of 10 years, be permitted to exercise the option to purchase the said estates. And your clients will be granted an alien's landholding license for this purpose. So, my lords, we say that it is clear from the correspondence and the license and the corresponding provision at recital E that the parties understood the position to be that the company were required to carry out the programme as a precondition of exercising the option.
So
Purchase.
does that mean that any breach of the development programme would entitle a refusal?
Well, we would say no. It doesn't follow at all.
Sorry, what
It doesn't follow that any breach of the development programme would. What we're looking at is
would the
whether
breach
or not.
have to be?
Well, this proviso is linked to the development programme set out in the schedule. I mean, no one is, if one's looking for the common intention of the parties, it would seem to us entirely clear that it is demonstrated by these documents. And they have nothing to do with the negotiation, but with the legal foundation upon which the lease was entered into.
Well, the question I asked was a different one. Is it your case that the effect of these documents is that any breach, however small, would justify refusal to give effect to a notice to acquire the ownership?
Well, no, I don't go so far as that.
So what's the test?
But the specific obligation to the 10-year term.
Well, that's the time at which you will be judging whether there was any breach. But you say, subject to that,
Yes.
any breach as at that date is fatal.
Yeah. Well, yes. I mean, obviously it would be subject to a de minimis approach. But we say that this recital records the position which was effectively the foundation on which the lease was negotiated and agreed, and that it was never in question. And it was the basis upon which the lease was granted and the company held the land.
The license says nothing about the payment of $1.4 million as a condition precedent to the right to exercise the option, although the lease says that it is.
Well, one would not expect the license to mirror all the terms of the lease. And indeed, one would not expect the license to refer to the payment of the sum. I would have respect for submission. The license is dealing with the basis upon which they're permitted to hold the land. But it doesn't, it would not be expected to mirror all the terms of the lease. But insofar as it contains this particular condition, it illustrates how important that condition was.
Yes. Well, I mean, at some point we're going to actually look at the contract.
We are indeed, yes. Yeah.
So these documents, I mean, assume you're right, they show what the intention was at that time. How do you make the legal link to the contract, the lease?
Because one has to look at whether or not the recital is overridden by the remaining terms of the lease or not.
Wait a minute, recital on the face of it is not, under most legal systems at any rate,
well,
an operative part of the document.
Well, your lordship, so to speak, begs the question. If in
But I only said under most legal systems,
yes,
certainly
yes.
The position under English law and under European law.
Well, my lord,
although perhaps sometimes honoured in the breach.
well, my lord, I think one has to acknowledge that the situation, the approach to construction, part of our case is that the approach to construction in St. Lucia is not the same, and that the recital is perfectly capable of being given full legal effect, and that indeed is recognised in the provisions in the Civil Code, which I'm going to come to a little later on.
Do you want to look at what the actual operative parts of the...
Well, I will do, my lord. I think I should perhaps have said to begin with, I'm not going to need my 2¼ hours, which we put in for. So perhaps I can just proceed as envisaged. And I think I've made the first point, which is that there should be no point that the parties considered as at January and February 1987, that this was a legal obligation by which they were bound. My lord, I've referred to Mr. Hofdahl. I don't know whether your lordships have yet had an opportunity to look at his oral evidence. As I say, he was the only witness who was concerned with the creation of the lease. It's in volume 2, you're using the volumes, at page 488 of the electronic bundle. Well, it really, in our submission...
Electronic?
488.
488, I'm sorry. It really emphasizes, as we say, what the understanding was. He deals with the background at 488 and 489. That's the negotiations with the Danes before the appellant company, the respondent company was incorporated. At 490, he accepts the proposition being put to him in cross-examination on behalf of the Attorney General that the reason why the lease was entered into was because Sir John Compton, the Prime Minister, wanted to control development. We see that on page 490, letters 6 to 7, lines 6 to 7. And he, again, accepts that further down the page, lines 14 to 16.
Yes.
There was a certain amount of interruption of the cross-examination, but it seems clear enough that he was accepting that if one looks at the top of page 496, that the option for sale was contingent on the satisfactory discharge of the development program. You see that Mr. Marcus was anxious to prevent the witness from being asked about his understanding at the time, but we look on page 496 when he's asked, would you agree with me that paragraph 2 of the letter, at that stage he's talking about one of the letters I've shown you, at least your clients would be contingent on the satisfactory discharge of a development program. The court says, I think he answered that before, he said so, he agreed.
Well, is this admissible under any principle of common law or civil law, if you rely on civil law?
Well, that depends on the approach which is to be taken.
Well, I know, but are you submitting that it's not admissible at common law? Is it admissible at civil law? You say that.
The express provision of the civil code which we'll come to is that one looks to the common intention of the parties rather than to the literal construction of the words. How broad that principle and how further it goes than the ordinary common law principles is, I suppose, one of the...
Well, I think you have to show us that the civil law goes further, don't you, than...
Well, as a start, I mean, do we actually get an answer to the question?
We don't.
If we do,
We get an answer from the judge.
admissible or not, it's not very helpful.
Well,
You said to have answered it before.
And I
think
that's the best you can do. You're not going to be...
Right.
yes, I think, well, on the page immediately before, 495 at the foot, would you agree with the
I mean, obviously they were making the point that this was all part of the deal, and the letters you've shown us.
Yeah. But the short answer to that is it was not part of the deal that they were to complete the development program within 10 years. It was a condition upon which they held the land under the license. So one is really not looking at your ordinary situation of a to and fro of negotiations between the parties as to whether or not this would be included in the lease and what it meant. The parties were perfectly aware of what it meant because it was a condition of the license upon which they held the land. And that is what the letters are about. They're not about, well, we say 10 years, you say 12 years, or something like that. Or we say the development program should include this. you say it should include that. They're about the basis upon which the alien landholding company is there in the first place.
Well, if it was a deal, a basic deal, and it remained the deal right until the signing of the lease, you would be entitled to claim rectification. But there's no case of rectification. It's a case of interpretation.
Yeah. But I was going to show you the passage in his evidence at page 500.
This case is about the right to purchase under the lease. There's no issue joined under the license itself. It's not suggested you withdrew the license for breach of the license, is it?
Yeah. The question is...
I mean, I'm puzzled by the license because of the dating, and it does seem to be a unilateral document. It's not. You're referring to it as agreement. Is there any evidence that either it was agreed originally, or that its amendment, presumably, to include a new second page, or add in document parts in the second page?
The license is not relied on for it being agreed between the parties. The license is something which the government can or cannot grant, or will not grant.
But you've got to rely on. I mean, in order for it to count as, so to speak, a collateral agreement, or a document which bears on the actual agreement, it would have to itself be a collateral agreement, and you're not suggesting it is. You're saying that you're...
Well, I wouldn't accept that it does have to be a collateral agreement, my lords. What Mr. Hofdahl said was the government told us that we would be permitted to lease the matter. And I showed you his paragraph. In due course, they granted the license, and on the basis, once the license was granted, we signed the lease. So the question for your lordships is whether or not recital E is effective as part of the lease. And the necessary background to that includes the fact that it was a condition of the license imposed by the government.
It's a factual matrix point you're making.
Yes, it is.
I mean, it looks to me, looking at the second schedule and the way the type operates in the license, it does look as if it may have come afterwards, doesn't it? And certainly the dating must come afterwards.
The reference to the date of the lease. Well,
yes.
Well, we can only go on the basis of the evidence, which...
No, but I mean, if it comes after the grant of the lease, it's going to be difficult to use it to construe the lease.
Well, except, my lord, that it plainly doesn't come after the date of the condition doesn't come after the date of the lease, because the condition is exactly that which is referred to in the correspondence, and which, indeed, the evidence from Mr. Hofdahl is that the lease was entered into after the license was granted, and he gives those dates in his witness statement, which I've already shown you. And it is also important, I think, to realise that the question of the timing was something which came from the respondent company. As you, I think, know from, well, you'll have picked up from my written case and perhaps from the documents, the lease was drawn up by McNamara and Company, who were the attorneys representing the Danish company. And the evidence of Mr. Hofdahl was that the basis for the development program, the details of the development program, were put together by the Danish company to recognize what it was that they were able to do and the results that they could achieve. What I think this is in Mr. Hofdahl's evidence, again at page 500. See at line 14, he says, do you agree, the question is asked of him, at page 500 in, again, volume 2, if help. Do you agree with me that the lease agreement that was drafted initially by River Dorée Holdings? The lease agreement was drafted by the lawyers McNamara, which was a River Dorée Holdings lawyer, including the development programme, and those documents were submitted to the government for their approval. Is that correct? That is correct. Would you agree with me, therefore, that at the time when the lease agreement and development agreement was drafted by River Dorée... I'm sorry, yes.
We can read...
Yes. Well, it's the last question, and on the page 500, and the answer yes on page 501. Then do you see the point? It is a factual matrix point. That
Everyone agrees there was a development programme.
Yeah.
The question is whether it was a precondition of the purchase.
Yes.
Which is a rather different question.
Yes. And the precondition is recited at recital E, and corresponds with the license which the government was prepared to grant the respondents. As we know from Mr. Hofdahl's evidence, the lease was put together by their lawyers on the basis of what they thought they could reasonably achieve. One asked the question, well, why is the recital there if it did not recognise the position which the parties understood to be the case? So we say it was plainly intended to record a legal obligation, and that is effectively the essential background against which the meaning of the lease has to be considered. And we repeat that the lease must be construed as a whole document. That is effectively what the master and the judge found. The master's judgment, can I just take you briefly to the crucial passage, which is at page 69 and 70 of volume 1, paragraphs 7 to 10. But again, I don't propose to read them out loud. It's really the master saying, what I'm concerned with is the meaning of the option itself. And in this, I think that regard must be had to the preamble of the lease at letter E. That's in paragraph 9. And in paragraph 10, he says...
the next sentence in paragraph 9 is simply wrong, isn't it?
Yes, I don't rely on the next.
No, but it's quite important.
Well,
but
Lord,
the reason why he thinks the preamble has to be looked at appears to be that otherwise you don't have anywhere where there's a basic rent provided, and you have it in a truncated clause 6 and above all in Schedule 2.
But he doesn't quite say that that is the reason why he...
No, it's obviously a fact.
Obviously something... I mean, it is reasonable for him to say, I think, that it's interesting to see that the rent is included in the recitals, because it would not necessarily be found there. But it doesn't follow that that is the only reason that he finds it, because he says in paragraph 10 that when the recital is read in conjunction with clause 9.9, it's clear that the option is conditioned on the lease having satisfactorily carried out the terms and conditions of the lease. He also says, my interpretation is, in my view, fortified by the fact that clause 9.9 specifically is made subject to 9.11, requires the defendant to grant the claimant an alien's land-holding license, which is to contain conditions designed to ensure that, as far as practical, the development programme, on pain of forfeiture of site land and buildings, shall be carried out in accordance with the terms of this lease. I don't think I propose to rely very heavily on that part of his reasoning either, because although it's not clear whether he means the first license, if you like, or some future license, which is what the lease appears to envisage.
Yes, if anything, that goes the other way.
Yeah.
So actually, the two, I'm not sure why you're looking at his reasoning, since you've abandoned both of the main limbs of his argument.
Well, Lord, I wouldn't. I rely on his reasoning because he says it's necessary to look at the whole document.
Well,
and he says when you look at and that isn't, I think, a controversial thing to say. The fact is that it contains both the recital and clause 9.9. I don't think I can really take up very much of your time with the points about the rent and the future license, but the combination of the recital and clause 9.9 itself seems to me to be a perfectly respectable basis upon which to construe the meaning of the document as a whole. Well, the judge, again, I've given the references to the parts of his judgment where he deals with this in my case, in paragraphs 7 and 8 of my case. So I don't think it would really be helpful just to point out that he agreed with what the master said, because he did. But he did go a little bit further. And you'll see where he did so. Again, his judgment's in volume 1, at page 150. The judge made a point which I've already alluded to this morning in paragraph 32. Of particular significance is the fact that in the evidence at the trial, the claimant, Mr. Hofdahl, admitted that it instructed its attorneys to draft the lease agreement and had identified the deliverables expected under the agreement after a thorough assessment of the estate property by its experts at the Solitaire.
Why, I mean, that's what you'd expect, but it doesn't help us as to the nature of the obligation undertaken in that respect, does it? Or the nature of the consequences if the obligation is not met. I mean, obviously people normally do assess, at least one hopes, the obligations they're entering into, and they expect damages, but it doesn't mean to say it's a precondition.
Well, except that Mr. Hofdahl was being asked these questions in the context of recital E, when he was giving evidence, as I took you to. Recital E is itself perfectly clear insofar as requiring the development programme to be completed at the end of the 10-year period if the option is exercisable. The other passage, perhaps, as I say, I've identified where he simply agreed. At the next page, I think the judge recognizes the point that, again, I've made this morning, paragraph 35, that the purpose of the lease was government-controlled development. And on page 157, we see the judge saying, what I submit is indeed correct. In paragraph 50, it's patently clear that from the very outset, it was government's intention that the option to purchase the land and buildings by the claimant company was always subject to the company carrying out an agreed development programme. That is the bedrock on which the negotiations proceeded and always rested. And again, we say that it isn't a question of looking at negotiations, it's a question of looking at a simple aspect of the background upon which the
Bedrock.
bedrock,
Lucia.
indeed. Well, Lord, it's a good term. And one then asks oneself, on what basis should recital E, which was included in the draft of the lease by the solicitors acting for the claimant company, be left out of account? Because the respondent's case requires the recital to be ignored, as though it was simply a waste of writing. And it is certainly the case that it is not repeated in the operative part of the lease, if that's the right way of putting it. It's not repeated in clause 9.9, which is why we're here. But if one looks at the Court of Appeal judgment, one sees why they reversed the judge and the master. The references are at paragraphs 44 to 48 of the judgment, which your lordships will find well, if I take you first of all to page 346. Paragraph 35. The judge, the acting Judge Carrington, who lordships may be interested to know was actually before your lordships last week, being led by Mr. Stevens in another appeal, which I think my Lord Conworth and Lord Hodge were party to, but he is the judge in this case. He refers to the master's decision. He says, Master Cottle came to that conclusion by having regard to the provisions of recital E, which he reasoned was necessary to consider in interpreting clause 9.9, because it is in the preamble to the lease that the parties have provided for the payment of the lease rent. We have briefly considered that point already, but it doesn't do entire justice to the master's reasoning. I've accepted that it was not a good reason, for the reasons I think put to me by my Lord Mance. But I've suggested already, suggest again, that in fact the master's conclusion was not solely based on that particular point. We then, at paragraphs 36 and 37, see the parties' arguments and the reference to Article 1141 of the Civil Code. And the Solicitor General's argument in the last sentence of paragraph 37, that whatever approach adopted requires recital E to be read in conjunction with clause 9 to determine the obligation of the parties under the latter clause. And then we see the basis upon which the Court of Appeal considered it. It is rather an odd feature of this case that the preliminary issue had been decided a long time before and not appealed then. But there's nothing to be added to that now. Paragraph 40, he rejects the single reason that he recorded as being the basis of the master's decision. And we see at paragraph 44 and 45 the reason why the Court of Appeal came to the conclusion it did. And it relied entirely on the principle that a recital does not govern the subsequent operative clause. My Lords, I don't know that it would be very helpful to take your lordships to the details of cases such as Mackenzie and the Duke of Devonshire. They don't, in our respectful submission, go quite as far as the Court of Appeals seem to think.
Well, what's the best authority from your point of view as to when a preamble can be taken into account in the construction?
Well, Lord, I haven't put any... no, I mean... I think
better look at the House of Lords then. I mean, if that's the... Is there any authority which...
Well, there's no authority which says Mackenzie is wrong, my Lord, and I don't, I'm not going to waste your Lordship's time by... I mean, it is a very different situation. I mean, the case of Mackenzie, which your Lordships will find at, I think it's tab 13, yes, if you've got, but the electronic number is 224. Referred to the distinctions between the narrative of a trust disposition which the truster had stated one thing, and in the dispositive portion of the deed, declaration was somewhat different. That appears from the head note. Lord, the judgments Salisbury at page 405 of the judgment 2729. I suppose the strongest bit of his judgment is about 6 lines down the page, 2730, where he says, I never in my life heard of the language of a deed which contained a perfectly unambiguous provision being twisted from the natural, ordinary meaning of the words by a preliminary statement of what the maker of the deed intended should be the effect and purpose of the whole deed when made. Lord Watson, at page 2731, says, the ground upon which the judgment of the court below proceeds really comes to this, that to read the words in the sense in which I thought they ought to be read would be at variance with the main purpose of the deed as declared in the narrative of it. My lords, I think that is carrying the principle of construction by intention too far. I can quite understand that where words are capable of being modified or qualified in the context in which they occur, it may be legitimate to ascertain how far one reading or another would best promote the intention of the maker of the deed. But I fail to see that the words at the commencement of the deed, which have been referred to as imperative, come to anything more than a statement that the deed was made because the truster entertained benevolent intentions towards certain persons who are included in the deed or were benefited by it. Lord Shand said, referring to the argument, top of page, bottom of page 2731, while saying at the outset of the deed that his purpose was to enable beneficiaries to support the dignity and title of the Earl of Cromarty, he might have thought it would better secure that purpose where heirs proportioners did succeed as females, that the eldest proportioner should have the income. I can only say that if he had any such intention, it is not expressed. The deed is an operative provision. It contains very distinct directions to the trustees. A little further down, although it might appear that there was a failure to fulfill the intention of the truster, I should still give effect to the operative words of the deed because his directions are given in distinct terms. It has been observed by the Lord Chancellor and by my noble friend who has already spoken, Lord Watson, he does not fail to carry out that intention, or in any view that may be taken of the deed, the eldest heir female succeeding to the estate of Cromarty does...
Well, that says there's no contradiction, so it's the previous bit that's relevant.
Yeah, and then Lord Davy says, I take it to be a settled principle of law, that the operative words of a deed which are expressed in clear and unambiguous language are not to be controlled, cut down, or qualified. Well, my Lord, the way in which the matter has been put in St. Lucia is that there is no real inconsistency between Clause 9.9 and the recital, because the provision in the recital can be used to explain or to the Attorney General said it's not inconsistent with it, it simply elucidates the meaning of it. The document as a whole, there isn't a difficulty, it's only if you contrast the two parts that the difficulty is. Lord, I think I should probably turn now to the particular St. Lucia situation. My Lords, I wasn't proposing to read it to your Lordships, but just to tell your Lordships, we included a chapter dealing with the hybrid situation in St. Lucia in the bundle of authorities. I hope will be of interest, if not decisive of the appeal, but it explains how the two systems have come to survive. It's I think it's divided 23, I think, Lord. My bundles slightly come to pieces. But I was, as I say, I wasn't proposing to read it.
What are we on at the moment?
Well, look, I wasn't. I was just telling your Lordships that I had included in the bundle that particular process. I rather thought that your Lordships.
Yes, we know about the two systems. Yes, the question is.
I didn't want to, so to speak, interrupt.
As a matter of interest, I noticed that they draw inspiration from the English version of the Quebec Civil Code. Does French survive at all?
In St. Lucia, yes, one hears maids in hotels talking in French patois.
Yes, so it's a patois.
But it is.
But not in legal.
No, not in legal
circles. No.
Interestingly, the Creole there is very similar to the Creole in Mauritius, which is another of the board's jurisdictions. But
well, there it very much survives. In
fact, the Quebec Civil Code. I have looked at it to see whether it threw any light on these particular provisions, but the provisions we mainly rely on don't have an exact equivalent in the Quebec Civil Code, so they aren't before your Lordships. I remember appearing in Pollinaire and Félicien some years ago. In fact, I think 17 years ago in front of Lord Hoffman, who asked me about Quebec authorities, and I've been rash enough not to look at all. And I found that quite a number came to be cited in the judgment when it was eventually delivered.
This was in a...
This was in a St. Lucian case.
Yes, I see.
Which is referred to in the courts of the these cases, but doesn't have any particular.
So where do we go now?
Well, I was going to take you to the provisions of the Civil Code itself.
Right.
Just before leaving that passage, I mean, your lordships may see references to Mr. Anthony as being one of the authorities who's written about the survival of the civilian tradition in St. Lucia. Mr. Anthony is, in fact, the Prime Minister who took over from Sir John Compton, and who, in the papers, is referred to as having possibly had some political motive in the background to this case. But in any event,
Took over from Sir John Compton in 1996.
Yes.
When his first term of office came to an end.
Yes, it would have been 1996, yes. Yeah. Right. The Civil Code provisions, well, we have, fortunately, they're in two places because the whole of Chapter 9 was not included originally in the bundle, but it's at Bundle 1, page 2372. Sorry, and
the cases, the authorities, you mean?
yes, sorry, the authorities bundle.
Yeah. Right.
We've referred to, under the general provisions, Part 2393, C917A, subject to the provisions of this article, from and after the coming into operation of this article, the law of England for the time being relating to contracts, quasi-contracts and torts, shall mutatis mutandis extend to this colony, and the provisions of Articles 918 to 989 and 991 to 1132 of this code shall be, as far as practicable, construed accordingly. Said article shall cease to be construed in accordance with the law of Lower Canada or the Coutume de Paris. And then there's some provisos I needn't, I think, read.
This is a very pragmatic solution. Which you incorporate, you enact the code, the civil code, but you provide that so far as possible it should be construed the same as common law.
Yes, but you also
subject to some exceptions, consideration.
You also add the particular provisions of paragraph 2 and 3, which have some relevance. Paragraph 1 of this article shall not be construed as affecting the provisions of the 9th chapter of this book, which relate to proof of obligations, or as affecting the provisions of the 5th to 16th books of this part, or of any other statute relating to specific contracts, save in so far as the general rules relating to contracts are applicable to such contracts.
That's something to do with specific contracts, which may or may not be relevant in the present case. Proof of obligation, it covers two things, proof of obligations and specific contracts.
Yes, yes. And then 3, where a conflict exists between the law of England and the express provisions of this code or of any other statute, the provisions of the code or of such statute shall prevail. And we have referred in our case to Article 945, which you'll find on the opposite page. When the meaning of any part of a contract is doubtful, its interpretation is to be sought rather through the common intent of the parties than from a literal construction of the words. And I suppose it's perhaps doubtful whether that is any different to the law in England.
Yes, standing what is said in 917A, you're not suggesting that that has maintained in St. Lucia a subjective approach to the interpretation of contract?
Not a subjective approach, no. But it... no, that's right. And then over the page 950, the clauses of a contract are interpreted each with the meaning derived from the whole, which again seem more or less to correspond with the approach which we are familiar with. 951, I'll just read, in cases of doubt, the contract is interpreted against him who has stipulated and in favour of him who has contracted the obligation. Well, can I then ask you, rather than continue in this bundle, to take the small additional bundle which contains the 9th chapter? We only included some of the provisions, but helpfully my learned friend has provided well, we should have a bundle saying respondent's additional authority.
Yes, I've got it. Thank you. Yes.
Unfortunately, we didn't include the earlier parts of the 9th chapter, which is entitled Proof.
Right.
And within that chapter, you'll see on page 2 of the additional bundle, Article 1141, an authentic writing is complete proof between the parties to it and their heirs and legal representatives, one, of the obligation expressed in it, two, of what is expressed in it by way of recital, if the recital have a direct reference to the obligation or to the subject of the instrument. If the recital be foreign to such obligation and to the subject of the instrument, it can only serve as a commencement of proof.
Well, that's an evidential point, isn't it? If you're trying to prove some fact recited.
Well, Lord, it's none the worse for that with respect. I mean, it's absolutely clear what it says.
Not sure it is very clear what it says. How do you say it applies in our case?
Because it is, well, I was first going to say that this is an authentic writing.
Well, I mean, it proves, you've got proof of what is said in the recital E, so we've got proof of that.
Well,
Where
it's
do we
got
go
proof
from
of the
there?
obligation expressed in the authentic writing.
Well, what is the obligation? There's a proviso in recital E.
The obligation is to comply with the proviso if the option is to be exercised.
Well, that slightly begs the question as to whether the recital is an obligation.
Yeah.
Well,
I mean, it's paragraph 1 you rely on, not paragraph 2, is it? Or what's paragraph 2 about?
well, Lord, paragraph 2 is relied on as giving the answer to the point being made that this is really only a matter about looking at documents, which is what the Court of Appeal thought.
I had thought, reading it, that 1141 was something like an entire agreement clause, that effectively the exercise of looking at preceding letters and so forth, which we've gone through, is excluded by this article.
Well, well, that throws one. I would respectfully submit that it doesn't have the effect of excluding any other means of proof.
Well,
In fact, that is looked at in one of the cases.
It suggests that it excludes anything else.
Yeah.
Well, it means that anything else is not strictly necessary, but it doesn't. I think, in fact, my Lord, that is a matter which is dealt with in one of the St. Lucian cases which we have, or considered at all events. But perhaps I should, first of all, just explain to your Lordships how this was put in the Court of Appeal at 316, page 316, which is in volume 1. I should just tell your Lordships that you're looking at the written submissions of the Attorney General in the Court of Appeal. Deed of lease in this case is an authentic writing. It's paragraph 5.6 at the top of the page. The document included in notarial form, and then there's reference to Article 1139. That is included in the short bundle which I've just ask your lordships to look at. A cursory reading of recital E indicates it's directly relevant to the collateral obligations of clause 9.9, can also be said to be directly relevant to the subject of the collateral obligation at clause 9.9.
This seems to treat paragraph 1141, subparagraph 2, as if it's capable of overlapping with subparagraph 1. In other words, as if you can derive obligations from recitals, which one would have thought was a bit unlikely since obligations have already been dealt with in subparagraph 1. And on the face of it, the second sentence of subparagraph 2 seems to make clear that there's a distinction between a recital and an obligation, and what this is dealing with is factual matters. It can serve only as a commencement of proof of a factual matter unless the recital has direct relevance to an obligation. It's all a bit mystical, but
well, if we rely on the first part, well, on paragraph 1 and the first part of paragraph 2.
Yes, but the question is, what significance is being given to recitals? Recitals normally recite factual matters.
Yes.
They don't recite or contain obligations. So on the face of it, one's looking, as the second sentence suggests, at recital as something which may prove a factual matter, preclude the parties from going behind it. And one can understand, therefore, why it's tied to something which has direct relevance to the core of the contract, the obligation. You wouldn't bar yourself in relation to other matters.
But surely what 2 is doing is distinguishing between two sorts of recital. And the authentic writing is proof of the first sort, which is a recital which has a direct reference to the obligation,
Yes.
which is the subject of the instrument. Now,
if you recite some fact which is absolutely core to what the contract's about, then you might expect to be stopped or precluded from going back on it.
Well,
that's the point.
I asked a rhetorical question, obviously rhetorically, but isn't that exactly the situation in the present case? The recital is reciting a fact which is directly relevant to the lease, and this is proof of it. I mean, that is this case. The recital proves itself and records the obligation. It would be different if the recital was foreign to the obligation, but it's not foreign to the obligation. It elucidates what is the basis upon which the option to purchase can be exercised.
Why do you say that recital E recites a fact rather than a proto-provision?
Well, it does both. It recites the agreement and obligation between the parties. And it's quite clear what it says. If at the end of the 10-year period, the tenant has complied with then, if he has done so, he is entitled to. I come back to the question of what is the purpose of the recital if it is not to record the obligation?
You're effectively saying that the parties are estopped from arguing that their agreement has any effect other than what is recited. So we don't look at the agreement.
It doesn't go so far as that. It's not necessary to go so far as that.
You seem to be saying that although this is set out as a recital, in reality it's not a recital at all. In reality it's an obligation.
Yes. Well, the difficulty is that one is familiar with, one is using sort of nomenclature, which is not, does not correspond to the reality of what the party's common intention was. If one looks at the whole of the document, and one looks at the background, and one the factual matrix, and one looks to see what the parties understood by the whole of the document, and it's quite clear in our respectful submission that they understood that this was to be a binding obligation. After all, it was put in there. The lease was drafted by the document was drafted by the attorneys for the tenant. One can put the matter in a number of different ways, but one comes back to the question of what is recital E doing there? It's not intended to be effective.
Well, it may be, as Sir Bernard suggested earlier, this sounds rather like an argument for rectification rather than one helping us to interpret the obligation actually in Clause 9.
Well, but it has never been put in that way, but it needn't be considered as an argument for rectification. It can be considered as a simple record of what the parties understood the obligations were into which they'd entered. Otherwise, ask the rhetorical question, why is it there? And we do say that we're entitled to look at 1141 supporting our argument. Lord, if this argument is correct, I don't think I need really go to the established English authorities. We don't disagree with any of the summary of the law in Rawlings, Arnold and Britton, etc. But I think mentioned in argument, or should raise the question of whether 1141 was intended to exclude reference to other matters.
Yes, the word complete
Yes.
is the...
If you're just kind enough to give me a moment, that is a point, I think, which is looked at in one of the cases from St. Lucia, which we've included in the bundle. I wasn't going to take them too in detail because I don't think they provide a particular clue.
No, let's have a look at it.
I think it's the case of Kent Dorée, and I'll need to hand up a complete copy, I'm afraid, because unless my bundle is the only one, it doesn't include all the pages of the judgment, which is divided 12. Mine didn't have all the
Okay.
and, it's a decision in first instance, Mrs. Justice Dauvergne, and the claimant, Mr. Dorée, was in fact, I think, the servant and the heir of Lord Glenconner, Colin Tennant, who owned Mystique.
Yeah.
And
well, this is one of the exotic aspects.
after he left,
probably not direct.
After he left Mystique, he went to live in St. Lucia, where, among other things, he introduced a pair of elephants, which roamed around the jungle until I think they've now expired. But his death led to a certain amount of litigation, of which this, I think, forms part of it.
Right.
And it's quite interesting because it shows the judge considering how to look at a number of documents together to decide on the result of the case.
So what's the point?
Well, I think the point that Your Lordship, a little difficult to explain. See that what was important was the meaning of a deed of sale, which is referred to in paragraph 4. But in paragraph 5, we see that on the 24th of June, the first defendant signed a notarial written instrument, hereinafter referred to as the avoidance of doubt document, which was executed before the notary in the terms which are then set out. If we go on to paragraph 13, you'll see that council submitted, this is council for the claimant, I think, the fact that the unregistered deed of sale was called a deed of sale did not deprive it of its lower status of an agreement for sale or an authentic writing or a private writing. In support of this submission, she quoted Articles 1139, 1141 and 1153, in the case of Goddard and John, the English case. I think the point that your Lordship raised is referred to in subparagraph 2 of the next paragraph 14. The fact that a written instrument purports to be or is called an authentic writing, e.g. a notarial deed of sale, does not deprive the written instrument of its lower status of an agreement for sale or other private writing if it has been signed by the parties thereto. Seems to mean that a document can be considered in more than one way. Paragraph 16, there's the argument that the avoidance of doubt document was a solemn statement by the first named defendant that the boundary was what it was, because that was at least part of the dispute. And there's a reference to Article 945 of the Civil Code, which you've seen in the next paragraph. I think one can go to the end of the judgment, where she says, paragraph 49, the defendant cannot be heard to say the unregistered deed is invalid because of its incompleteness, since the proper inference to be drawn from the signature on the deed is that the first named defendant trusted the executing notary to complete the deed. This conclusion is further supported in the avoidance of doubt document, which clarifies the southern boundary of the 7 acres. I agree that the common intention of the first named defendant and the claimant was if and when the future plan of survey was executed, the relevant particulars and results of the plan of survey would operate to complement and complete the registered deed of sale. And it may be that that case might have been framed as a claim for rectification, but what seems to have happened is that the judge was prepared to look at documents in order to establish what was the common intention.
Well, yes, but only because, well, in this context, the unregistered deed of sale actually had a reference to a plan of survey to be completed, not yet completed.
And then there was
when it was completed, have I got it the right way around in terms of date? When it was completed, it could be read together with.
Well, she also read it together with the avoidance of doubt document.
Yes, I see, yes.
But the object of that exercise appears to have been...
That was a prior document.
To look at the common intention.
Yeah.
And in doing so, to look at at a series of documents rather than just the one. But the present case we have, the material which we say that your Lordships need to consider, all contained in the same document. It's a question of deciding whether this is the Mackenzie, Duke of Devonshire type of situation or nothing of the sort. And we say it isn't comparable to the more familiar question of whether the recital alters the operative clause. So I haven't taken you to the operative clause itself, which is in the lease. I use the words operative clause, but you'll appreciate that I don't want to fall into the trap of distinguishing between recital and operative clause, which I say is not as not clear-cut. Really, it's a very short point. If one looks at the opening words, at any time after the end of the 10th year of the term hereby created, the tenant may give notice, or the lessee may give notice. That is not, does not rule out reference to the recital. Indeed, those are the places where the 10-year period is referred to.
Well, the provisions of the sale are to be consistent with the obligations of the lessee in this lease. In other words, they are to continue the obligations. The license is likewise to contain obligations to ensure that, so far as practicable, the development programme should be carried out on pain of forfeiture, so that on the face of it, you've got your clients have several protections. Firstly, they had the right, while the lease was in force, to re-enter, terminate, if there was a breach, at least if it was a substantial breach, one can leave that aside. And then secondly, if the notice to purchase was given, they had a right to sale documentation and license documentation which reflected the terms of the lease. And if they hadn't already terminated, but had stood by while there was a breach, then perhaps they could, under those, since the obligations would continue, give notice to perform the development programme, albeit late, within a reasonable time, and then terminate on that basis. But why does one need to read more into the actual provisions of the lease, leaving aside the recital, than that?
Well, no doubt the first part of your Lordship's observations are all true. There were protections in the lease to my clients, but it doesn't follow that the recital should be considered as without any meaning and effect, which is effectively what Bonner's case. We take those words, proviso, simply meaningless in the lease which their own attorneys drafted, and in which they're clear, and in which we might correspond with the basis upon which the parties were negotiating.
The alternative view is that this document gave you rights to pull out at certain points if the development programme wasn't performed, but what it didn't give you, at least expressly in the terms, was a right to hold up ordinary performance of the agreement, which included transferred property, if you didn't decide to pull out completely. And as I've said, it may be that after transfer of the property, because there are provisions for forfeiture and so on, you could still have pulled out completely if you wanted to. In the event you didn't decide to take that course, you took a different course of compulsory purchase.
Well, except that what in fact happened was not quite like that. What happened was that when the 10-year period was up, the lessee wrote a letter saying that they were entitled to exercise the option. We said, well, wait a minute, we need to see whether or not you have complied with the proviso, and that exercise led to all the reports, etc., which were considered in a great length in the...
Yes, but this may be a problem in ascertaining something as complex as whether there's compliance with the development programme. But does it throw any light on the construction of the agreement?
Well, I think the way the judge put it was that we received from the letter which was written by, I think it's about page Sorry, if I could just give me a moment. The judge referred to a letter written by Mr. Hofdahl in September 1999. I'm afraid I haven't got the page reference to it just at the moment. What he said was, we see that Mr. Hofdahl here was hedging his bets. He was saying we were entitled to the exercise the option, and we've complied with the development program, which is the way in which the matter proceeded. But the two things are not, I would respectfully submit that it is not necessary to confine oneself to what we think of as the recitals on the one hand and the operative parts of the lease on the other hand. One looks at the whole document in the context of it. The various matters which I've alluded already this morning and don't need to go back to, one sees it was quite clearly intended by these parties that the obligation to recycle was binding. One can be confused by the terms which are used, but it is one document in which both those obligations are recorded. And there is no inconsistency in enforcing the clear terms of recital E simply because clause 9.9 does not set them out again. Lords, can I just, I think I've almost completed what I was proposing to say in support of the appeal, but can I just deal with some of the matters which are raised against me by my learned friend in his case? In particular, we go to paragraph 10 of the respondent's case. We're criticised as putting forward matters as background against which these should be construed. And the first point is made that they relate to the negotiations between the parties prior to the grant of the lease. Well, I hope I've demonstrated that on our analysis, they don't go to anything of the sort. They go to the government's position was always the same. It didn't involve negotiations at all. It simply said, we're not going to sell this land to you. You're aliens. We're prepared to lease it to you on the basis that you complete a development program within 10 years. And then when that situation, which, as he said, paragraph 15 and 16, that the letters relied on were written in June 1986, in other words, 8 months before the lease was determined. Well, that's subject to the point I've already made, that there was no negotiation about this involved at all. It was...
well, obviously, obviously must have been some negotiation. This is a very complex lease, unless you just signed it.
But not on the subject of recital E. That was something which was written in stone from the beginning, and there's no indication that
that's a rectification point, isn't it? I mean, well, you can't confine the concept of negotiation in the way you are. As in, it includes all the precursors to the actual agreement.
Well, respectfully, I maintain my position about this. I mean, the government, the occupation of the land by the alien company, or company with alien ownership, was a matter which the government could either agree to or not agree to.
Yes, right.
And indeed, the government, not just 8 months before the lease, but
By the license.
to this point, by the license,
Yes.
never budged from the condition of 10 years. We say this is not part of negotiation, it's part of the factual background just as much as the fact that the land was there. And so it is not...
It's part of the factual background, what, that your clients intended something?
No, the lease was granted in respect of land over which they never had more than a license to occupy, subject to a condition that they carried out a development program within 10 years. And that was a condition which was spelled out in the license. It exactly corresponded with the position which was taken in June 1986, and it was repeated in the license which you've seen. And that is, according to Mr. Hofdahl, granted in January 1987, so shortly before the lease is entered into. So, my learned friend's point that all that I've shown is that at one point of the negotiations, that was what was being considered, simply isn't right. The basis upon which the land was held is that which is set out in the recital.
You refer repeatedly to completion of the development plan within 10 years. Where do we find that in either the license or the lease?
It's in the recital itself refers to if it has have carried out.
Yes, but it's an ongoing programme because there are timescales, obviously, for certain things in the development programme. But Clause 911 envisages the government giving a licence as owner and securing in that licence the continued compliance with the development.
That is contingent on the exercise of the option. That's
Yes,
part
indeed.
of it.
Yes.
So the scheme of it is, if after 10 years you've completed the development programme at that stage, we will grant you a further licence for you to continue with the development programme after that stage. And indeed, I think I've already taken you to that part of Mr. Hofdahl's evidence in which he said, well, yes, we devised the development programme, which is attached to the lease, and I think it's Schedule 6, in order to correspond with what we consider was achievable.
Yes, and you recognise, I think, that paragraph 9.9 involves the if the option is exercised, the government would be entitled in its deed of sale to impose on the purchaser the obligations of the lessee, including continued compliance with the development programme. So the government would be protected in the deed of sale and also by the licence in paragraph 11. Is that right?
Yes, but
Yes.
why? But with respect, why? I don't think that is inconsistent with our funding.
No, but what I'm trying to get at, I mean, you're telling us that the purpose of this hearing is now because it affects the compensation. If you are right and there isn't an option to purchase, then presumably the government will argue that you're buying out a leasehold interest which you say is subject to forfeiture because of non-compliance, and therefore a third party wishing to buy the leasehold interest would take into account the likelihood of forfeiture.
Well,
And would not exactly the same apply in relation to the situation if instead of a leasehold interest it was an ownership interest, if that ownership interest is objectively subject to forfeiture?
well, there would still have to be the investigation into whether or not the development program had been carried out.
Yes, but so I mean what I'm trying to see is, why do you say that the outcome of this will affect the amount of compensation?
Well, Lord, I haven't, I have to confess, looked in great detail as to, it appeared to me that my understanding is that the issue of compensation has been effectively deferred until
Yes.
the situation is proposed by whatever your lordship finds.
I suppose if were you to fail were you to fail to uphold the judge's ruling that there had been a failure to comply with the development plan, a material failure, then I suppose the compensation of a leasehold interest would differ from an ownership interest.
Yes, if at the end of the day, if the issue of compliance with the programme is decided in my learned friend's favour, then plainly we're going to be in a much worse position on the question of compensation than we would be otherwise, because we would not be able to say that they were not entitled to exercise the option.
But it does seem, whatever the outcome of this appeal, the courts in St Lucia are going to have to determine the question of the extent of compliance with the development programme and its consequences.
Yes, subject to possible settlement, I suppose. Yeah.
I mean, there are questions which I'm not sure that the judge has answered in his judgment as to whether the degree of non-compliance justifying forfeiture under either Clause 9.1 or else under any license or arrangement made on sale, whether the degree of compliance of non-compliance was such as to meet the standard required. In other words, there may be one reads into those clauses that there's got to be a repudiatory breach, for example. That doesn't seem to have been addressed.
Well, it's implicit in his findings that he thought that, however, although the government might be open to criticism, there was really no answer to the fact that the development programme had not been completed.
But was he dealing, the other point which is unclear to me from his judgment is how far he was actually focusing on the position in 1997 or the position in 2009 or even, well, I suppose it must be when he heard the trial, when he conducted the trial. At times you read his judgment as referring to one and the other, and there seems to be a strong argument that if your clients were obliged to transfer ownership in 1997, then their failure to do so really had some adverse consequences on the further performance of the developments programme because River Dorée couldn't get funding. That I think he more or less accepts, the judge.
Well,
so, I mean,
I don't think you can ask me to accept it. I mean,
no, but I mean, whether he does or not, it was certainly River Dorée's case. There are quite a lot of issues which I can see can arise at some point, potentially anyway.
Yes.
Yeah.
Well, my lords, I think I've probably covered the ground that I intended to and taken you to the documents I intended you to see.
Yes. That's helpful. We'll just go out for a moment to see where we are, and we'll be back shortly. Mr. Dowding, we don't need to trouble you on any difference between St. Lucian and common law. And we think you can address this quite briefly, as indeed Mr. Guthrie has. We would like to hear you, firstly, on the licence point which Mr. Guthrie raised, whether that's of significance and how you answer the points he's made. And secondly, you can tell us where you place recital E and what significance you attach to it. Is it, on your case, simply a mistake? Is it of no relevance to the construction of the body of the contract? So on those points, I think fairly succinctly.
I will be as succinct and quick as I can be. My Lord, the part of the difficulty with the licence is that although it, as my learned friend says, it was referred to en passant in Mr. Hofdahl's evidence, it was never relied on at trial or in the Court of Appeal or indeed in my learned friend's own printed case as a relevant matter of background. If your lordships look at I'm not suggesting he's not entitled to add to it, but if your lordships look at my learned friend's printed case, what it refers to are the two letters. It doesn't put the licence forward as part of the background. So, my lord, so far as we can see, the question of the licence, the factual circumstances, were never explored at trial. And that may, of course, have no significance if the licence within its own four corners were comprehensible and easy to follow. But for the reasons your lordships have really alluded to, it's a little bit of a difficult document to fit into the general scheme of things for a number of reasons. First of all, there is the
Which page is it at?
my lord, it's bundle 3, the electronic bundle, page 1247. And,
have an endless number of date stamps,
well,
some
quite.
before it and some...
Well, quite, my lord. It's quite. It resembles a sort of formulaic calendar. If your lordships look at the bottom of some lines up from the bottom of 1247, the date of the document is said to be given by the Governor General this 12th day of January, 1987. But there is then two further stamps on that page, one of which is December. Your lordships have seen those.
The 30th of December and 5th of March, and then over the page there's 10th of December.
Right, and then there's the 2nd of February, which there are only two possibilities about it. I mean, one is that that's been typed in, as it were, after the document was said to have been, the licence was said to have been given, because it's later. Or the licence wasn't given on the day it was said it was given later on. I mean, that's the only way of reconciling that. And the difficulty is one just doesn't know, because it was never an issue which needed to be investigated at trial. But, my lords, putting that on one side, even on the terms of the second schedule, the B is a truncated reference to whatever option is going to be granted, and isn't wholly consistent, partly for the reason given by my Lord Sir Bernard Riggs, with the option as it appears in the lease as executed, because the only condition there expressed to be is that if after 10 years the lessee's complied with A, which is developing the property in accordance with the lease, whereas on my learned friend's case, the condition precedent to the exercise of the option based on the recital has to go very much further than that, because that is not only compliance with the development programme, that is compliance with all the other terms and conditions of the lease as well.
Right.
So one has a tension there. As the point was made, so in other words, it's not on the face of it a condition you pay the rent of 1.4 million, which it is under the lease. It's not a condition that you serve a notice, which it is under the lease. And it's not a condition that you comply with any of the covenants, which it is under the lease. So, my lord, that's my second point about that. The third point is that it is, of course, a unilateral document. It's a licence given by the government, what one has no evidence as to the extent, if any, to which the intending lessee was involved in that, or whether it was simply an administrative act from some office in the government which had no reference whatever to what was passing between the parties at the same time. My Lords, fourthly, there is no, and this is important, there is no link between this licence and the lease. And the lease doesn't say, as it might have done, this lease is granted in pursuance of the licence dated whatever it is, which might have given one some, as it were, a linguistic link between the document to be construed and the unilateral document, which is the licence. And, my Lords, lastly, it comes back, in my respectful submission, to the use of background material to contradict clear words in contracts. You can construe the words in the light of the matrix of fact, obviously. The words to be construed here, we would say, are the words of the only provision in this lease which grants the option to purchase, which is clause 9.9. I mean, what's been referred to as recital E, whether it is a true recital or not, does not purport to grant any legal right of any kind. It doesn't purport to confer any legal obligations. It's simply part of the preamble, and in answer to my Lord Mance's, the second part of my Lord Mance's invitation, I will see the way we put that in a moment. But the operative provision to be construed is clause 9.9, and that, yes, in my respectful submission, is clear as a bell. And so this isn't one of those cases where one can use the background material, as it were, to contradict, and it would be contradicting, the clear effect of plain words. Lords, no doubt there are cases, in the cases that your lordships have decided, where background material is sufficiently powerful and sufficiently probative to make it clear that the parties must, which I think is the word used by Lord Hoffman in ICS, must have used the wrong words. But this, in my respectful submission, comes nowhere near that.
Right.
My Lords, all one can say about it is that it came into existence at some point, whether before or after the grant of the lease. It may or may not have had some involvement on the part of River Dorée, so that it doesn't really, given that there are uncertainties in those respects, really get off the ground as part of background material, because the one characteristic which is legally essential to background material is that it can't be unilateral background material. Something's got to cross the line. It's got to be something everybody participates in.
Right.
You know, we don't have the provisions under which this licence is granted, do we?
We don't, my lord. I'm afraid it occurred to me this morning that we might not have helped your lordships as much as we could have done by not putting them in, but we don't have them.
I mean, the trouble is that this licence purports to be a legal document in its own right.
Yes, it does.
And one could understand someone seeking to enforce the terms of this licence, but that's not what's happening here.
Right.
It's sort of being prayed in aid as a sort of instrument to help one.
Yes.
It seems rather odd. But actually, I'm just rather wondering whether one can have a licence under this Act which says that you can be sold some land in 10 years' time. I mean, normally a licence, presumably the licence to enable you to do something now, and it's not the job of a licence to, under this Aliens Act, to permit you to buy some land in 10 years' time, is it?
My lord, I quite see that. Another way of putting that, maybe your lordship's drawing a distinction between A and B in the licence, because A might be thought of as a true condition. You have the licence on terms you develop the land. Yeah. But as your lordship says...
There's probably something which says, well, you lose the licence if you fail to comply. That doesn't really work with B.
Quite. Well, my lord, that is another difficulty with it that I respectfully add to my list.
Yeah.
Right.
My lord, I'm not sure I can take the matter of the licence very much further. Those are, I hope, sufficiently succinct for your lordship's purposes. Your lordships haven't asked me to address you on the two letters. I've dealt with
I don't think you need worry about
my lord, so far as the rest of the lease is concerned, Can I just introduce that by saying this? My Lord, it follows the entirely conventional format of a professionally drafted formal lease granted by deed. It starts off with the parties. It then has some preamble, which is introduced by the word whereas. And whereas, of course, is the conventional way of introducing a recital or preamble, or I think it may be called narrative in the law of Scotland. In other words, some preliminary part of the deed, which the draftsman wishes to put in for whatever reason, before one gets to the bit of the deed that actually does the job the deed is intended to do. And so after whereas on page, I don't know which version your lordships are using, whether it's my learned friend's, attached to my learned friend's printed case, or in any event, on the first page of the lease, after the 5 recitals in whereas, one then has witnesseth as follows, which again is the entirely conventional way of introducing those parts of the deed which do the job. And if your lordships then look at clause 2, where the typing's gone slightly wrong, but one can just see this is the grant, and the government leases onto the lessee all that land and buildings described in Schedule 5 for the period, and upon the terms hereinafter appearing. So the grant is upon the term. It's rather difficult to see because the paper's obviously slipped in the machine. But the grant is on the terms hereinafter appearing. In other words, appearing after clause 2. So nothing thus far in the lease is telling the reasonable person whose job it is to tell us what the words mean, that anything he's seen already is an operative part or is going to confer any legal right or obligation or anything like that. Now, my Lord, leaving aside for the moment the cases on recitals and operative provisions and all that, if one just applies if one approaches it in the way your lordships have repeatedly said it is to be approached, by saying, well, what would a reasonable person make of all this? He would start, in my respectful submission, with clause 9.9, because that's the provision that confers the right to buy. It appears after clause 2, and it's introduced by witnesseth as follows. And my lords, what one sees in that are a series of points. I've already made the point. Firstly, it's the relevant operative provision. That is to say, it's the provision that actually creates the legal right to purchase. Secondly, it plainly and clearly does not make prior compliance with the development programme a precondition of the right to buy the freehold. And my Lord, thirdly, in that respect, it is perfectly plain and unambiguous.
How would it work if there hadn't been prior compliance? Let us suppose there hadn't been prior compliance, there hadn't been a re-entry under clause 9.1. The new deed of sale must be consistent with the obligations of the lessee in this lease.
Yes.
How would the lessor's rights be preserved?
Well, my Lord, it's important perhaps just to pause at the first of those points, because the right of re-entry in the first part of the lease, that's to say the period of the lease before the exercise of the option, is a critical part of the commercial scheme of this, because what it entitles the landlord to do is to forfeit at any time during the first 10 years, because the option doesn't arise until the end of the 10 years. So it's a crucial part of the government's armoury in enforcing compliance with the development programme. So if the development programme is not complied with, there would be a right of forfeiture under clause 9.1.
Yes, but Mr. Guthrie would say, I think, did say that you couldn't form an immediate view about that. Supposing you think that there may have been a breach, but you, in fairness, require to investigate that. Here it took an amazing number of years to investigate, but how does the requirement to issue a deed of sale, which you say exists, combine with the expectation that the lessors might be able to reserve their rights and work out whether there has really been a sufficient breach to justify forfeiture?
Well, it would be the same problem that you always have when one party asserts a breach and the other party denies it, that if there are legal consequences which depend on whether there's been a breach or not, you don't know whether those legal consequences flow until you know whether there's been a breach.
But you're saying that they've got to, if they haven't got to the point where they can assert a breach, because forfeiture is a big thing, it would be a repudiation and render them liable for damages. They want a bit of time.
Yes.
You say they've got to enter into a deed of sale. Now, having done so, does this contract allow them to preserve their potential right to forfeit? And if so, how?
Well, my lord, in my submission, it would, because there are ancient incrustations on the English law of landlord and tenant, which require one to distinguish between once and for all breaches and continuing breaches for the purposes of the law of waiver and that sort of thing. But if the deed of sale and the licence both said that you must comply with the development programme on pain of forfeiture, then the moment, as it were, the ink was dry on those documents and there was another breach of the obligation to comply with the development programme, then a fresh right would arise. So there would be a seamless transition.
It wouldn't be another breach. It would be a continuing breach.
It would be a continuing breach. Yes.
Would you have to give? Would you have to give some sort of notice to? Or would you have to give them a reasonable time to comply? Or
well, my lord, the only thing I can tell your lordship, I think I'm right in saying this, there is no statutory right to relief from forfeiture in St Lucia as there is in this jurisdiction. That is not to say that there may or may not be some form of equitable jurisdiction to do it. My lord, if there's no statutory right, there may be no statutory equivalent of Section 146 in this jurisdiction, which requires a landlord forfeiting a lease in England to serve a notice giving the tenant an opportunity to remedy the breach and so on and so forth. My lord, but even if there was a requirement to give a notice, that would be part of the enforcement armoury, because it would be the formal way of saying to the tenant, comply with your covenant or you're out. So it would be an important prerequisite to the control mechanism which forfeiture gives. If there is any form of right to relief, then that would not be granted consistently with the principles elsewhere, unless the breach were to be remedied. So again, the arrows all point in the same direction, that the right to forfeit is the way of controlling compliance with the development programme in the first 10 years. And subject to your lordship's point about there being, as it were, a hiatus while the parties argued about whether there's a breach or not, there would be a seamless transition into the next regime under the deed of sale and the licence, under which those same rights simply continued into the future. I'm sorry.
Suppose a day before the option was exercised,
yes,
the lessor had said, we don't think you've been complying with the development programme, and we're not simply going to re-enter, we're going to investigate this.
Yes.
Next day, the option is exercised.
Yes.
So could the lessor in those circumstances say, well, all right, we have to sell you the property,
yes,
for $10, but we want a term put in the license which we have to make, that you have not been performing the development programme. Could they say that?
Well, my lord,
And that this is to be investigated?
I suppose if it's a continuing breach, it's not clear why they would want to say that, because I can see that if there was some technical argument in circumstances as yet unforeseeable, that the entry into the deed of sale somehow waived something earlier, but it's hard to see how that would be the case. So the government would simply be protected by carrying the obligation on. So, my Lord, whether that would be covered by the language of 9.9, I'm not sure. But in my submission, it wouldn't have any, if I can put it this way, it wouldn't have any commercial content doing that because there
Wouldn't be any point.
Well, quite.
It'd be covered.
Quite.
I suppose, I mean, an variant on Sir Bernard's point might be a provision simply reserving rights in the licence,
Yes.
since it contemplates it's got to be consistent with the obligations of the lessee
Yes. Yes.
under the lease. That would be, couldn't be objected to.
Well, my Lord, it would certainly be odd, I certainly accept this, if a deed of sale which the government is obliged to enter into could be itself construed as somehow extinguishing in that kind of way. But, my Lord, it does happen. Indeed, it happened in some of the cases, the English cases, on the relationship between forfeiture and options to purchase, that once the tenants exercise the option to purchase, then a new and independent contract for sale arises, which on the authorities is not affected by the forfeiture of the lease, that the new independent contract acquires its own life. But that wouldn't be a problem here, because the new and independent contract has the provisions your lordships have seen that require the regime to be carried over.
Right.
So, my Lord, the only other point your lordship made is, sorry, I didn't mean this quite as rudely as that came out. The point your lordship made, not the only other point.
Well, I'm sure it was the only other point worth addressing.
Is this question of the hiatus. So, my Lord, if the government alleged a forfeiture before the right to exercise the option arose, say in the 9th year of the lease, well, that would have to be investigated, and if it took as long as it has, then it may be that the question of whether the government was obliged to execute a deed of sale would be something that would have to be resolved after the event, as it were.
But here you exercise the right.
But that would be. I'm sorry to interrupt.
Sorry, here you exercise the right before.
Yes, but my Lord, exactly the same problem arises on my learned friend's construction, because all his construction does is shift the battleground to a different contractual provision. In other words, the contractual provision isn't the forfeiture provision; it's the precondition that he says exists. So if I exercise the option, and the argument is, as it is, we haven't complied with the precondition, there would be the same hiatus, as indeed there has been in this case, while whether the precondition's been investigated, has been breached, would be investigated. So, my Lord, one has that hiatus difficulty in my submission, really, whatever route your lordships choose to deal with the matter. My Lords, just going back to...
Can I just be clear, the sort of second part of Clause 11
Yes.
becomes fairly critical on your argument, because that really ensures that the objective of tying it to the development agreement is carried out. As you say, it sort of carries you on into the new regime.
Well, my Lord, and 9. I mean, one's got 9.9 as well, which is the obvious.
Yes. I mean, there's the words in 9.9 so as to be consistent with the obligations of the lessee. So,
but it's the point of having the pain of forfeiture carried into the sale, which is slightly unusual.
Yes.
Was that discussed? I mean, we've looked at the letters beforehand. Was that discussed at all before? Do we know where that came, how that arose?
No, my Lord, part of the problem, I didn't go into this in detail because your lordships don't want to hear about the letters, but the problem is that the two letters were introduced into evidence by my side, Mr. Hofdahl, and there was no exploration that I can see at trial at all of what happened after they were written. Yeah. So, I mean, if they'd been put into the frame from the word go, as an important part of the background, no doubt the learned judge would have heard evidence as to how they were answered and whether they were agreed, and how all of that, of course, would be relevant in a rectification action. But we simply don't know. All we do have, as I've indicated in my printed case, is that the evidence was the negotiations took about 8 months. We do have that.
Yes, but all I'm putting is really a point in your favour, that we can't assume that between the letters and this, there weren't very significant changes in what was planned, and one of the changes we do know about is the introduction of this specific carry-on provision in the new option.
Where do we get the 8 months negotiations? Then you say
I'm so sorry, my lord. It's Mr. Hofdahl's witness statement. If your lordship give me 2 seconds, I will just give you the reference. It is bundle 3, page 1200.
Yeah.
It takes a little bit of understanding where he runs the 8 months from, but I won't trouble your lordships with that now. It's fairly obvious when you look at it in context.
June to February.
Exactly so. My lord has got there very fast indeed. It took me rather longer to get there, but in any event, my lord, it's plain, that's what he means.
Which was that page again?
1200.
Bundle 3, page 1200, my lord. So, my lord, just returning to my list of points one gets out of 9.9, I think I said that it was clear and unambiguous. The flip side of that is it doesn't contain anything whose meaning needs to be elucidated.
I think you said that, yes.
I'm sorry, my lord.
That clause 9.9 is clear.
Yes, quite. And my lord,
There's no need for any implication. You say it's catered for by the
Quite.
references to preserving the position, effectively consistent with the obligations and the forfeiture provision.
Exactly. And my lords, the word "in which event" are as clear as they possibly could be, that all you've got to do if you want to buy is to serve a notice. My lord, one doesn't get round that difficulty by repeatedly insisting, as my learned friend does, and indeed as the master referred to, that a contract's got to be construed as a whole. Because, of course, one doesn't look at the relevant clause in isolation. One doesn't look at 9.9 in some Faraday cage without the intervention of any outside force. One looks at 9.9 in the context of the document as a whole. So you can construe 9.9 by reference to the remainder of the lease. But what you can't use the recital to do is to override its plain meaning. And what is being done here, stripped of its pretenses, is that another commercially very significant precondition is being read into the clause 9.9, which says no such thing, indeed, which provides precisely the opposite, because it says if you serve a notice, you can buy the freehold. And so, my lord, as far as the recital goes, if I just come back to that for a moment. My lord, I'm sorry, before I get to that, could I just add one, as it were, ingredient into the commercial scheme mix, which your lordships, I'm sure, will have picked up from the printed cases. But that is that the scheme of the lease is that the entirety of the basic rent will have been paid by the end, effectively the end of year 7.
Yes.
And it is common ground that the entirety of the basic rent, that's $1.4 million, represented the purchase price for the land, which is why you only get 10 Eastern Caribbean dollars on the deed of sale. So the whole of the consideration will have passed some 3 years before the option becomes exercisable. And if obviously it hasn't passed, then there would be a right of forfeiture to enforce it. I merely mentioned that in passing. Lord, so far as the recital is concerned, well, my lords, when they're introduced by whereas, it's a sort of, I suppose it sort of means seeing that or considering that or something like that. What these recitals are doing, or at least in most part, is, as it were, sort of reciting or anticipating some of the provisions to be found in the lease, in which regard they are really very similar to the sorts of recitals the courts had to consider in the English cases, dealing with the relationships between recitals and operative provisions. Whereas I intend that my will benefit Mr. X, and then you find the operative provision says the will benefits Mrs. Y. And the courts have had no difficulty at all, and it's a very, very long-established principle, this, in saying, well, if you do get that situation, then the statement of intention or preamble or whatever one like narrative, whatever one likes to call it at the beginning, is the subservient provision. Of course, you can use it to construe the principal operative provision if there is some part of the operative provision that requires illuminating by reference to the recital, and there are cases where that's happened. But if the operative provision's clear, you can't. And so, my lord, the effect of that rule, the necessary effect of that rule, is you may end up with a recital which is redundant or surplus or even contradictory. But I mean, that's the effect of the rule. If your lordships remember Lord Davies' principle, that if the recital is unclear and the operative provision is clear, the operative provision prevails. If the recital's clear and the operative provision's doubtful, the recital prevails. But if the operative provision is clear, it prevails over even a clear recital. And it must follow from that, and it's the logical consequence of that, that you may end up by that process with a recital which is mistaken in some way, or doesn't go far enough, or is, and my lord, all of us who've had experience with recitals in commercial contracts and leases and all that have come across many times recitals which are unhappy, have an unhappy relationship with the body of the operative provisions. But that's why the courts have developed a body of law which deals with that. So my lord, I do just offer your lordships this. If your lordships just look at the recital at 1231E, the proviso that my learned friend places very heavy weight on is the lessee has satisfactorily carried out the terms and conditions of this lease. Lords, of course, there is a situation where if the lessee hasn't satisfactorily carried out the terms and conditions of this lease, the right to buy won't arise, and that is where if the landlord elects to forfeit.
Yes.
So, my lord, it is...
It could be a shorthand reference to that.
Exactly so.
Yeah.
I mean, it could be that that's what the draftsman had in mind. I entirely accept that in another context that would not be the natural way of reading it. I accept that completely. But if one is trying, as it were, to make everything sing in the same key, then that is at least a possible way of explaining what might have been going through the draftsman's mind. Well, he might have been thinking, well, bearing in mind as I do the forfeiture provision, everything will then hinge on whether the tenants...
The alternative is that it's simply a reference to something which might at one point have been intended, but it's superseded by the more detailed provisions.
Yes.
There is a slight oddity, isn't there, that clause 5 actually it is, to get a renewal for 25 years, there is there an express provision that all relevant terms and conditions have to be satisfactorily performed. So,
yes.
Again, that seems to be, I mean, that cuts both ways, perhaps.
Well, my lord, I accept entirely it cuts both ways. I, in my respectful submission, although it cuts both ways, it cuts with a slightly sharper knife on my side than on the other side. My lord, because of the... I mean, that's something the draftsman's obviously given thought to and put in expressly. And it does become, to use my learned friend's own rhetorical question about the recital, very odd indeed to see why the same wasn't put into clause 9.9 if that was intended. And my lord, there is an explanation, and that is that if the option to renew is exercised, the parties would be in the continuing relationship of landlord and tenant. And it is for that reason, one sees this in the extract from Mr. Barnsley's book on land options that's in the cases, and I think referred to in my printed case, that these kind of conditions tend to be very common in options to renew, but very uncommon in options to purchase. And the reason they're more common in options to renew is because if the parties are in the continuing relationship of landlord and tenant, the landlord may want to start again with a clean slate. But, my lord, I accept it cuts both ways up to a point. But it is an example in my submission of a condition precedent which doesn't appear in clause 9.9. My lord, there is another contrast. Your lordships may well have picked it up already, and that is that the clause 9.2 says you can only assign after the basic rent has been paid. So that's another example of a precondition. The draftsman's created a legal right, but it's subject to satisfaction of a precondition. So, my lord, the way I answer your lordship's question is this, that a reasonable person weighing it all up would, for all the reasons I've given, say, well, recital E is simply an inaccurate part of the preamble as regards clause 9. One doesn't know how it got in there, but it's simply not right. It's not an accurate reflection of what is to be found in the operative provisions of the lease. And that if one wants the safest guide to the parties' intentions, one finds that in the unambiguous language of clause 9.9. So, my Lord, that's my, I hope not.
Can I just draw to your attention, it may not matter, Sir Kim Lewison seems to think that the rigidity of statements in cases like Mackenzie needs to be qualified in the light of more modern methods of interpretation, in which background plays a larger part. That's at page 2868.
Yes.
And he cites
yes.
New South Wales authority to support his view.
Yes, he does, yes.
I mean, it doesn't really affect the way you put it now, because you just say, in fact,
Well, you draw a distinction between clear and unclear substantive provisions.
Yes. Well, my Lord...
More flexible, is he?
I think what he may be getting at...
Yes, 22868.
Oh, yes.
My Lord, I think what he may be getting at is simply to emphasise that the Mackenzie rule doesn't require you to put the operative provision in a Faraday cage, as it were, and leave the influence of the recital out of it. What you have to do is to construe the operative provision in accordance with the usual rules of construction, that's to say, in its context and all the rest of it. And my Lord, that first of all, would strike one at first blush as being right, because we don't have technical rules of construction as such anymore. My Lord, secondly, here, it doesn't, as your Lordship says, affect the way I put it, because I say it is clear. And thirdly, I don't want to take your Lordship's time up with the cases, but I'm going to give your Lordship a list of 4 cases in a moment. If your Lordships want to see how the English rules developed, your Lordships may not be at all interested in that.
Not a lot.
But if Mackenzie being very...
Yeah, I mean, they're all set out in Lewison.
Well, they are, and quite.
And it's just, you don't need to say that it's a rigid rule.
No, quite.
And we have now the exposition by my Lord Hodge of how we deal with interpretation in the modern world. So.
Quite. No, my Lord, what I was going to say is that Sir Kim may be putting it slightly too rigidly himself if he suggests that those cases in some way need to be qualified in the light of the modern law, because in fact if you read the judgments in those cases, they're really very careful to say you don't look at the operative provision in vacuo, you look at it in the light of the document as a whole. So it may not be quite fair to those judges to say that they were applying a sort of exclusionary rule rather than what we would recognise today as the right way of looking at it. My Lord, that's particularly true of some of the statements in Mackenzie and Re Moon, which is another one of the cases I cite. My Lord, I think...
So you say the principle is you look at the operative provision in the light of the document as a whole, including the recital?
Yes, my Lord. I'm clear, I mean, the principle itself accepts that, but if you find what you can't do is to say a recital can be used to contradict a clear operative provision. I mean, that rule really comes in. If you look at the operative, you'll see an example in Re Moon, which is perhaps the best example, where the operative provision was frankly all over the place, and the recital was absolutely crystal clear. And so the court said, well, the operative provision remains the operative provision. The recital's not the covenant. The covenant's the operative provision. But in seeing what the ambit of the covenant is, we can look at the recital to see what was intended. But you're putting the cart before the horse if you do that, as it were, the other way round, with a recital on a clear operative provision. My Lords, I'm sorry to gabble, but I don't know whether those answer your Lordships, at least.
Thank you.
Thank you very much. Yes. Mr. Marcus, you wish to add anything?
No, please, my Lords.
Thank you very much. Yes, Mr. Guthrie.
Well, only a moment. And I'll confine myself to what Mr. Downing has said. It is correct that I didn't place as much emphasis on the license in my written case as I have done today. I'm afraid that does sometimes happen. But there doesn't seem to have been any real doubt about it in the courts below. I took your lordships to what Mr. Hofdahl said about it at page 1200. But if I just remind you that he explained the history of the matter beginning at page 1199, he referred to, and it was he who introduced a correspondence, a letter of the 24th of June, referred to the grant of the license. That's page 1199. If, however, your clients carry out an agreed development program, your clients will, after a period of 10 years, be permitted to exercise the option to purchase, or such their offers mutually agreed, for the sum of $10, and your clients will be granted an alien's landholding license for this purpose. He then referred in 3.1 how on the 20th of June 1986 we got permission to lease the lands by letter. I signed the lease document on the 20th of February 1987, the license having been issued on the 12th of January 1987. So he plainly linked the two things together. The Court of Appeal did refer to the grant of the license at page 339, that's in volume 1. It's in paragraph 10. And they set out the schedule to the license and the conditions that it contained. And they referred to the fact that it had been granted by the Governor-General of St. Lucia on the 12th of January 1987. My Lord Carnwath asked about the legislation under which license is granted. My Lords, I've been able to turn it up on the internet. I can provide a copy of the Aliens Licensing Act. Section 3 of that Act provides that an alien may apply to the Cabinet for a license to hold land. Section 3.2, Cabinet may, if it thinks fit, grant to an alien a license to hold land as owner or as lessee for a term of not less than 2 years, whether subject to any conditions or not. And Section 5 provides that an unlicensed alien shall not, save as otherwise provided for in the Act, hold land, and where an unlicensed alien contravenes that section, the land held by that alien shall be forfeited to the government. So the, as I summarize it, the holding of land without a license or in breach of the conditions of a license renders an alien liable to forfeiture. But there is a case.
Yeah, but that's a lease, and that you need it to give the lease authority. What it doesn't tell you about is granting, selling the property after 10 years. There's nothing in the Act about doing that.
No, but
that seems to be pure surplusage.
The Act, no, the Act doesn't say what, but the point, I suppose, is that really they were required, if they were to hold land at all, to have a license. The Act entitles the government either to grant a license or not, and to include conditions or not. And we know in this case that the government decided to grant a license and to include conditions within it. And I think in relation to the second question that your lordships asked me earlier, where you place recital E, my answer is this. Recital E refers, if you like, to the 10-year term, and indeed the background to the 10-year term, which is the license under which the land is held. That is a given, and it is a part of the background which is inescapable. You say, why is it there? And a learned friend says, well, it's an inaccurate reflection of what is eventually set out in clause 9.9. Surely a much more commercially reasonable answer is it is there to recognise the fact that this is the basis upon which the land is held.
Right.
And the reasonable observer looking at it objectively would come to that conclusion. Well, that really is the way in which we put it.
Yeah, thank you very much indeed. Is that...
I wasn't going to add anything else.
Well, the board is grateful for the submissions which have been addressed to us succinctly, and will take time to consider what advice it will humbly tender to Her Majesty.